Well, hello, Colorado real estate investors, Colorado landlords. Mark Cunningham at Grace Property Management. This last month, a very important case came before the Colorado Supreme Court, and their ruling impacts you if you're a tenant, and it impacts you if you are a landlord or real estate investor in Colorado, because what it did is it changed the rules of rent collection and the eviction process on all tenants in Colorado, in essence extending the timeline and requiring you as the landlord to go through some extra hoops and extra things you have to do when a tenant doesn't pay rent. Now, the result of that is that it's extended the timeline it's going to take to potentially evict a tenant who does not pay rent. Now, nobody likes evictions. It's the worst case scenario for a landlord as well as a tenant, but sometimes tenants don't pay rent, and when that happens, it's necessary for a landlord to go through the eviction process, which has just changed. And it's changed in relation to the CARES Act. So if we could get in a time machine and go back to, when was this? This was in March 2020. This was in the depths of the COVID crisis, if you remember that. And the federal government passed the CARES Act. The CARES Act stands for the Coronavirus Aid, Relief, and Economic Security Act. That passed, and it did a couple things. One thing it did is that it imposed a moratorium on all evictions. So no landlords can evict any tenants, and it imposed that moratorium. It was supposed to expire in July of 2021. Now, it kind of got extended a little bit, and different states played with it, so it was kind of a soft expiration date, but it was supposed to expire in July of 2021, and it did those two things. It paused evictions, and it also did a second thing. It created a notice provision requiring all landlords to provide tenants with a 30-day notice before you begin your eviction process on what they considered covered, quote, put that word in air quotes, a covered property. That was another requirement of the CARES Act. Well, what's a covered property? A covered property is any property that has government subsidized funding in any way. So for example, and there's a list of 12, 15 different types of properties that are covered, but some of the big ones are things like this. Public housing would be considered a covered property, so a landlord would have to give the tenant this notification, and they'd have to give them a 30 days. Section 8 housing vouchers, Section 202 housing for the elderly, or any property that has a federally backed mortgage. So if you as the owner of the property have a Fannie Mae or a Freddie Mac mortgage, that means the mortgage is backed by the federal government and your property is considered covered, and you fall under this umbrella of the CARES Act, meaning you have to give a 30-day notice to the tenant before you can initiate the eviction process. You say, well, Mark, that's all interesting, but the CARES Act expired, so what is the big deal? Well, here's why. Technically, if you read the CARES Act, what it said is that the eviction moratorium would expire in July of 2021, but it didn't specifically say the notice requirement would expire in July of 2021. Now, everybody acknowledges, no matter which side of the argument you take on this, everybody acknowledges that the purpose of the bill was to have the whole thing expire. The whole CARES Act was supposed to just be done and washed away, but technically, it just said the eviction moratorium would expire, and it didn't say the notice provision would expire, the 30-day notice requirement under covered properties. Now, most states just kind of threw it away. They said, hey, the whole thing's expired, we're done. But there's been a handful of states that attorneys have said, no, technically that expiration did not happen for the notification, and so landlords, you still need to give a 30-day notice to your tenants on properties, and you have to have this notice provision if it's a covered property. It was a poorly written bill. That was kind of what they did to rush through that process. So in Colorado here, our court systems in some counties have said the CARES Act is still in effect. Other counties have said no, it's not. It's been very, very difficult because it's been on a county by county basis. Well, last month, this went all the way up to the Colorado Supreme Court to rule whether or not the CARES Act still applies in Colorado. And the Colorado Supreme Court ruled that yes, the notice provision in Colorado is still in effect per the federal CARES Act. Now, they admitted it's a poorly written bill. This was a quote from one of the the Colorado Supreme Court justices. She said, if Congress made a mistake and intended to include an expiration date for the entirety of Section 9058, that's the provision on notices, then it should amend the statute. We are not empowered to rescue Congress from its drafting errors and to provide for what we might think is the preferred result. That was Justice Melissa Hart. So they kind of acknowledged, yeah, We know this is what they meant, but technically they didn't say it, so we're going to keep the CARES Act in place. Now, there's only been 4 states that are still working and holding to this CARES Act, which has technically expired: Connecticut, Oklahoma, Washington, and now word number 4, Colorado. So what does this mean for you as a Colorado real estate investor? It means, number 1, you need to know if your property is covered. For most of you, that means you have a tenant that receives federal or state funding from the government. If the tenant receives Section 8 or any kind of government subsidized funding, you're covered. If your mortgage is covered by the government, the backing, if it's federally backed Fannie Mae, Freddie Mac, then it's covered. You need to provide the tenant a 30-day notice, and you need to give them some disclosure documentation at the time you initiate an eviction process on that property. End of the day, what does this mean? It means evictions are going to take another period of time. Right now in Colorado, the notice period is 10 days notice before you can initiate any type of legal proceeding on a tenant. Rent's due, you have to wait until it's delinquent, then you have to give the tenant a 10-day notice. Unless you are covered, unless the CARES Act applies, which it does to everybody, but if you are a covered property, now you have to give the tenant a 30-day notice before you can even initiate the eviction process. Now, the challenge for landlords, of course, is rent's due every 30 days. So you can't do anything for a 30-day period, which is going to take you into the next month. Now they're 2 months delinquent. It's going to stretch the eviction process out. We just completed what we hate to do, which was an eviction on a property when a tenant had moved in and stopped paying rent. Evictions in Colorado are taking on average about 3 months, 90 days. That's how long it's going to take from the time the tenant doesn't pay to potentially actually getting a sheriff out on the property, which is a terrible thing to do. But if a tenant refuses to vacate, if they refuse to pay, they refuse to move, it's going to take you at least 90 days to get that property back into your possession as the owner of the property. If you are an owner-client of Grace Property Management, don't worry, we have all this covered for you. We will, by the way, be reaching out to you to find out if your mortgage is federally backed, because we need to know if we need to operate under the boundaries of the CARES Act for our owner clients. But if we can be of an assistance to you in helping you understand what's going on as a landlord, feel free to reach out to our office at Grace Management. Jump onto our website, rentgrace.com. We're happy to be a resource if we can.